All right, at this point, we'll hear from our second panel, Alan Epstein from Epstein Engineering, Mark Balsam from Redox, and Josh Serrett from ALC Environmental.
We'll do Alan and then Mark, and then you, if you will. Madam Chair, if I may just set this up, I've invited, this panel actually addresses some of the questions before that were asked by Scott and Helen about unfunded mandates. Pat delivered a long list of such mandates. I've invited three people in three different aspects of this field. They're here pro bono to try to give you some concept of what these costs are. Alan Epstein is president of Epstein Engineering, does facade work. Josh Serrett, president of ALC Environmental, who does lead abatement work, and Mark Balsam from Redox, who is involved in the nascent field of energy benchmarking and energy audits. These two areas, facades and lead, well established, very costly, so that'll give you some indication of where these costs can go. Mark's area of energy gives you an indication of something that's just beginning to build and where more costs will be coming up. So I want to thank in advance these gentlemen for coming down and sharing their expertise with this board. Thank you.
Thank you.
Good morning. My name is Alan Epstein, and I am the president of Epstein Engineering. We've been in practice for 20 years. Prior to that, I was in practice as a sole proprietor for more than 10 years. All told, my practice is almost exclusively in the area of Local Law 11 compliance. Just to give a brief history on the law, Local Law 11 pertains to public safety. It's a requirement that buildings which are greater than 6 stories in height have their facades inspected and repaired periodically, and reports and updates are filed with the City of New York. During my tenure in the industry, aside from our professional practice, I've been actively engaged in working with the representatives of the Buildings Department in terms of implementing appropriate changes to the law and tracking its success and perhaps shortcomings. The really primary and almost sole goal of Local Law 11 is public safety. We've all seen, I'm sure, periodically tragic accidents that occur when materials and debris fall from facades or partial building collapses occur. The public safety aspect of it is actually heightened when you think about tenancies and visitors to a particular building. While the public moves along in general quite freely along our sidewalks, it's very often the occupants of the building who benefit from the requirements of Local Law 11 and the enhanced facade safety. The law was originally enacted in 1980 as Local Law 10 in response to a tragic accident that occurred up near Barnard College, where a student was tragically killed as a result of some falling masonry. The city enacted the law, and it basically required the front facades of all buildings that are greater than 6 stories be inspected every 5 years. Thereafter, there were a series of other accidents which occurred as it relates to back walls, and ultimately the law was modified and Local Law 11 replaced Local Law 10, essentially requiring that all the facades be inspected and repaired. This dramatically changed the whole playing field, increased the intensity and the magnitude of the inspections, revealed more conditions, and had a very significant cost impact in terms of compliance. Typically, these accidents are what triggered the initial law, what's triggered the major changes. Through the years, we've seen the law expand. Recently, there was an accident on 57th Street where a young woman who was an occupant of the building fell off a balcony because the railing collapsed. The law was then changed as a result of that, And now there are very intense railing requirements that are now part of Local 11. Fire escape systems are now inspected under Local 11. So we've seen quite a bit of change and quite a bit of growth in the law. Currently, again, the law still pertains to buildings that are greater than 6 stories in height. There hasn't been a movement recently to require some more changes. There's been talk about having more scaffold inspections where typically in the past the buildings were inspected by binoculars and supplemented by one scaffold inspection at the building. The scaffold affords the inspector an opportunity to check the masonry from up-close vantage point to really get better data and more reliable data. Increasing the number of scaffold inspections will drastically increase the price. There's also been a talk about bringing more buildings into what's called the universe and to change the notation of greater than 6 stories to move buildings that are actually 6 stories. That will increase the magnitude, particularly in Brooklyn, Queens, and the Bronx, where there are a lot of buildings that are precisely 6 stories that have not previously been covered by the law. When an inspection is done, the inspector typically will classify the building itself in one of 3 categories. If the building has been well maintained and has no conditions in need of repair, the building can be classified as safe. No further action needs to be taken under Local 11 for 5 years until the next inspection is required. The second category is safe with a repair and maintenance program. These are conditions that are not deemed imminently hazardous, and the building owner is typically granted 5 years to repair these conditions before the next inspection is due. The third category are the buildings that are unsafe, where there are unsafe conditions at the building. This triggers a lot of activity, a lot of expense, and a lot of involvement on the part of the property owner. Initially, they're obligated to put up a sidewalk bridge over the sidewalk. They're also required to file repair plans with the City of New York. They're required to implement repairs and retain various consultants, including engineers, contractors, expediters, and so on, so that the process is properly implemented. Many buildings are found to be unsafe, those which sometimes do not have the funding for these projects, which themselves are, for the most part, well into the 6-figure range. We'll put up the sidewalk bridge to gain some sort of temporary relief, temporary staying of the various penalties and fines. However, ultimately, the repairs do have to be performed. The conditions will deteriorate, will escalate with the passage of time. And it's only a stopgap measure to just have a bridge sitting there. It's also an eyesore, and the building department is, again, clamping down in the time frames with which to implement the repairs. At this point, all buildings are now within the inspection and repair cycle, which will run from 2016 through 2019. Buildings are given staggered deadlines during which time to implement their repairs, and then the process repeats itself 5 years later. Basically, it's not an option, it's a safety statute. The inspections have to be done. There are very, very heavy violations, which range from not having an inspection report done. If you have an unsafe building and you don't immediately put up a sidewalk bridge, there's a whole other series of violations, and then if you don't prepare the conditions in a timely manner, there are further violations. So it's one of these things that we feel in our practice, we hear constantly, it's something that slips through the cracks. It's not an ongoing maintenance issue where it's done every year or even every 2 years. It's something that comes up every 5 years. It's tremendously variable. The weather has a huge impact. If we have bad weather conditions over a 3 or 4 year period, a lot of freezing, we will find that the buildings are worse at the end of that stage. So in addition to being variable time-wise, it's also variable condition-wise. Even if the landlord or the property owner has basically done everything possible, there's still likely to be conditions that recur every few years. I think that covers pretty much what local law 11 entails.
Thank you. Why don't we go on to the next speaker, and then we can come back to questions.
Great. Hi, my name is Josh Surratt. I'm the president of ALC Environmental. I have an environmental consulting firm that's been around in New York City since 1997. We specialize in lead-based paint compliance, working with property owners, architects, engineers, but primarily property owners, as well as public agencies. My firm has about 70 people in it that perform these services on a daily basis for various types of environmentals. I want to speak today specifically about Local Law 1, and that is different than Local Law 11. Local Law 1 is the Environmental Lead-Based Paint Compliance Act of 2004. So previous to that, there were different types of laws out there in New York City, Local Law 38, but we came along and in 2004 and passed Local Law 1, which requires lead-based paint compliance in pre-60 multifamily rental buildings. Okay, so every multifamily building that's built prior to 1960 and is rental units, regardless of who's moving in, is required to have make the apartment lead safe on unit turnover, which means to address all the peeling, chipping, flaking paint, which means to make sure that none of the windows and doors bind, rub together, scratch together as to create hazards, and then to address the windowsills, specifically was in the law, and then ultimately to take dust wipes by a third party, such as a company like myself, to make sure that the apartment is lead safe for the tenants to move in. At that time, they also receive brochures and information and a copy of the test results. That's just the New York City portion of the law. There's also the federal portion of the law, a federal law out there governing lead-based paint, requiring disclosure of any known lead-based paint hazards. You give out a pamphlet, and you're required, the tenant has the opportunity to test, and that just applies to pre-78 housing, all housing pre-78, not just pre-60. There's also, as you move along in this, under Local Law 1, which I'm going back to the New York City law, also requires addressing any peeling, chipping, or flaking paint where a child under 6 resides. So if a tenant calls up, has any peeling paint, they must correct that hazard quickly and again take dust wipes to do that. There's also an aspect of the law requiring training. Where workers need to be trained in safe work practices. That's building supers, handyman, all of those guys. So the federal law has been around since '96. The New York City law really in this form since 2004. There was also another law passed in 2010 for the federal law requiring what's called the Certified Renovator Law, where they required all firms doing work in pre-78 housing to get a certified renovator license and to get their worker, at least one, trained in safe work practices so they can train others if they're on site, but so they can work lead safely. This is what's been going on, so you need to pay for that training. So I want to talk about some of the costs. So you have the costs involved in this law of complying with the law. That includes, using special workers, trained workers, using 6 mil poly, using other controls that you wouldn't normally do in your normal everyday business routine. So you need to make sure that those are taken into account per the regulation. Cost of that can increase the average cost of a renovation by 15 or 20%. In addition to that, you're required to take dust wipe samples at the end, which range around $250 to $300 for every test. And that's required to be done every time someone moves in and out of that apartment. So the only way you can get out of that is by getting it exempt, which is to use an XRF machine, which we do as well. But once you've identified that lead, the law will require you to disclose that as you move forward. So there's other nuances there, and other costs come into play because obviously you're identifying lead and where it is. The law is really a disclosure law, but also a lead safe law in the form that it's written now, making the unit lead safe. It doesn't need to be lead free. as these laws have kind of galvanized over the years, we saw obviously a big spike in 2004 when the law came out. My firm can do up to 1,000 inspections a month. So we're talking about substantial numbers. We've gotten a lot of people exempted from these by using the XRF machines. But most of your larger landlords were taking this into account and knew the law was coming in, and they actually were aggressive in testing and different types of testing programs. Over the past, what I would call 4 years, we've seen a significant drop-off in testing for our firm with clients that we know have it. And as we've kind of discussed with them, they've come up with things, or it moves around. It seems there's difficulty in paying us. So we're seeing this as evidence that it's very difficult. And even though the lead laws are, what I would say, enforced in New York City, so there's not only regulations, but enforcement. We've heard from owners that, hey, maybe we'll just have to take a violation. So the concern comes to the public health of the actual occupants in that apartments if shortcuts are being taken. And this has become new because, hey, you're saying, well, it's a couple $100 or $250, but as you hear these small property owners and the ones that need it the most, because these older buildings are the ones that can be in the most distress. These are the people where we're seeing them not following or not in compliance with law. Now, they can say, hey, I'm ignorant of the law, I don't understand it, and we get a lot of that. So there's always someone that calls, I didn't even know this was out there, I didn't even know what I would do. But more often than not, we used it, people used us and they stop and we ask why. Well, it's a lot of money, we didn't need to do it this time, or, well, there's really no child going into that apartment. Well, the law isn't written that way. The law doesn't say if it's a child moving in, it's regardless of who moves in. So you're seeing people where it's becoming a situation where dollars and cents are compromising public health and safety. And now this law was written as a public health law, right? So you have disclosure where you want people to know and be aware of what's going on with lead. It's going to become another issue as we go forward, as it becomes nationalized, as you hear the problems that are going on in Flint, Michigan, and things like this. But I want to be clear here is that we've done thousands and thousands of water samples, and we've never had any issues with water in New York City. So remember, lead in the paint is much more dangerous than lead in the water for everyday purposes. So you have the costs which range from, another 20% for remediation for lead hazard control work, which is just to make it lead safe, the apartments, to correct violations. You have procedures that are in place which you need to do, which are good policy. And then you need to do dust wipes and third-party testing, which is what we do. The other component of this that we've heard problems in hearing about it from is there's a record-keeping component of the law requiring you to keep the records for 10 years under Local Law 1. Well, who's keeping those records? Who's doing the annual audits? So you're allowed as a property owner to go out and inspect your property, and you send them out with the lease notifications, the window guard notices. Many of them do it through RSA and other established places. These cost money. These things to get that, and then to get the notices back, you need to have someone organize that information, identify where a child under 6 is living, and then you need to go out and do a physical inspection of that property, that's the ownership, to determine if there's any lead hazards, i.e. peeling, chipping, or flaking paint. And then if there is, you have just a year to correct those hazards, to send somebody out and correct them, and then you need to take dust wipes again. This also applies to common areas and public spaces. So it's not just inside the unit. So let's say that you have just a couple of apartments move in and out. Well, you still need to make sure that you're looking at all your floors, your hallways, your stairwells, to make sure there's no peeling, chipping, or flaking paint. The only thing out of the purview of this law attached to the building is fire escapes. So these costs are there, and we find a lot of people over the years have had trouble administrating this regulation, not just the small property owners, but the large ones, of keeping their records. And the records are just as important to have a chain of, hey, what happened in this building? What's the history of this building? But we see people doing this every day, and we saw a big drop-off, and I'll tell you exactly another point when we see business has gone down, was after Hurricane Sandy. So they said, well, I guess I couldn't get it. I mean, you see what's going on and the struggle, and I can also just tell you as a business owner, it's a struggle to get paid on this work. So, I mean, this is what we're saying from this level of what's going on with the property owners. As I said, I came here today to talk about it, but you can see where the issues are, that we get this from them, the costs are associated with this. If 10 years ago you said, hey, I'm going to hire someone for $32,000 or $34,000 to administer this in my office, well, people want raises just like everything else. So we hear this, they want to make $50,000 or $55,000 now. It's not 2004, it's not 1988. And these are the issues that we're seeing on the other side, which affect tenants and compromise public health and safety for those tenants, the people that need it the most. So that's where I would speak to that in these regs. And this is what it is. As we know, lead is a serious issue, not just in the water that you've heard about, but primarily in the paint, which is created by lead hazards in the dust. That's it. Thank you.
Thank you, Mr. Balsam.
Good morning. My name is Mark Balsam. The name of my company is Redox, Inc. We're primarily involved with Local Law 84, which is an energy benchmarking requirement, Local Law 87, which is the energy audit and retro commissioning requirement, and to a lesser extent, some of the new boiler efficiency requirements that have been instituted through rule changes at DEP. The first two laws came into being as part of the Greener Greater Buildings Plan in 2009. They actually came into effect a little later, benchmarking in 2011. 2013 was the first year for the energy audit and retro commissioning requirement. And I just wanted to speak a little bit to what's involved in these and the costs. Local Law 87 is probably the most substantial. Essentially what this law requires is buildings over 50,000 square feet have to undergo a energy assessment, which is a two-part assessment. The first is an energy audit, in which consultants such as ourselves is hired to go through the building and make energy-saving recommendations, which are not mandatory, but it is mandatory that we make these recommendations and file them as a report with the city. The second component of Local Law 87, which is typically done in tandem with the energy audit, is the retro commissioning assessment. These are 25 items listed in the law, in the original legislation, that again, a consultant such as ourselves has to look at while on site, and if any of these items are found to be deficient, the building owner then needs to correct these items prior to the filing date, which is December 31st of the year that that particular building is due. Examples are pipe insulation, boiler tune-ups and efficiency, control set points, sensor calibration, things of that nature. Local Law 84 is the energy benchmarking requirement. It requires, again, the same set of buildings over 50,000 square feet to report their energy usage to the City of New York.
I'm sorry, when you say 50,000 square feet, how big of a building that is to put that?
Picture 50 units. It just to give you a general, understanding of it. And by the way, as of yesterday, Local Law 84 was proposed in the City Council to extend that now to buildings 25,000 square feet. And extending both of the laws that I'm talking about to 25,000 square feet was part of Mayor de Blasio's, I think it was called Built to Last plan, which he put out a couple of years ago. So there seems to be a trend towards extending the threshold on these buildings to 25,000 square feet. Local Law 87 is still relatively new, and so you have a wide disparity in the prices being charged for it, anywhere from about $5,000 for an assessment for, let's say, a 50-unit building to $17,000. I know that's a big spread, but those are the existing prices that are out there just to do the assessment. On top of that, the actual required retro commissioning work, also I would estimate ranges from about those numbers as well. So, and that has been trending worse and worse for building owners over the last few years. The Department of Buildings is proving to take a very strict interpretation of what was a vague law. And so we're seeing these costs both in the assessment and in what's required on the retro commissioning going up over the years. On the benchmarking, it's a smaller cost, but it's a yearly cost. It's about anywhere from $300 to $800, depending on who you hire, per year. Again, I think it's actually the mayor's office that's overseeing this one. The Office of Sustainability is adding data quality checks and certain new checks to the submissions which were not present previously. So that's added to the costs. And again, as I said, that law looks like it's going to be extended to smaller buildings as well. Finally, just really quickly, there's the DEP requirement, which is actually was done about a year ago. There's now boiler efficiency standards for certain size boilers. Oil burners need to meet 83% efficiency. Gas needs to meet 80% efficiency. What this has done is basically double an owner's yearly tune-up costs. Typically, owners do some form of tune-up or overhaul every year. These new requirements have about doubled it.
Thank you. Questions? Yes, Helen?
So, I guess, beginning with Mr. Epstein, I was wondering, do you have an estimate just on your work of what percentage of the buildings end up having to do significant facade work, I guess fall into that third category of the inspection results?
Yes, I would say roughly 60 to 75%. Most buildings, 5 years is a long period of time, particularly in the older building stock, where we have brickwork, terracotta, brittle materials that are very susceptible to weather patterns. And the freezing winter is the #1 cause. If we have one bad winter in those 5 years, we're going to have a lot of problems.
Should I just keep asking? I just have one
Sure, go ahead.
more. So on the energy audit, is that a one-time audit or is that an ongoing one?
It's currently it's once every 10 years, and it's dependent on your building's the last digit of the tax block. Again, there's I think legislation. I don't know what stage it's at to make that once every 5 years.
And is there an estimate on your side? Presumably, if you make your building more energy efficient, you do have some savings in terms of your energy
Right.
costs, correct?
Well, it's a great question, and I'd say yes, and it's very theoretical is the best that I could describe it. And I think that's actually one of the things that the city is intending to study as part of Local Law 87. So basically, the purpose of this law is in part to study that exact question. And I would just add one other thing, which is NYSERDA, which is a state agency, administered a multifamily incentive program to similar sized buildings. And basically what it was you had to do an energy audit and project energy savings. So if you could project, in other words, if your engineer could project 15% and it was backed up by, substantial, well-documented numbers, they would release a certain incentive amount per unit. And this program, I think, went on for about 10 years. It's going into a new iteration now. But what they did some sort of like an analysis, like a scatter plot chart, and what they found is about 50% of the buildings, when they actually verified whether they hit these savings a year later, about 50% of the buildings hit what was projected, and about 50% underperformed. So it's hard to answer your question definitively.
Offer a follow-up to that. Before September 11th, I built a building in Battery Park City, 22 River Terrace, which under the Battery Park City plan, it had an identical building right next to it, which was built by the Albanese company that was the kind of gold standard for green buildings in New York City. Battery Park City went through a process to benchmark our building, which I would argue was very energy efficient, but we did not do gray water recycling, and there were a number of things we didn't do because they weren't economically feasible for a rental. And what was interesting to me was similar to your kind of 50-50 comment, that study was never released because it did not show conclusive results. So I think some of the theme of this group is a lot of these things are the right things to do from a public policy standpoint, but they do have significant cost implications, and they're the right thing to do. I mean, we do need to reduce our carbon footprint, but reducing our carbon footprint has costs.
Other questions for this panel? No other questions? All right, thank you very much, gentlemen.
Thank you.
So now we'll move to our third panel, which is Mike Slattery from the Real Estate Board of New York, Marianne Rothman from the New York Council of Cooperatives and Condominiums, and Jack Freund from the Rent Stabilization Association. Very.
Oh, and here's more testimony. Shall we go, or shall we wait for,
I think you should go ahead.
Yeah, okay,
If
let's-
you don't mind speaking while the materials are being passed out.
not at all. Thank you very much for the opportunity. I'm going to ask Marianne to lead off.
Good morning.
Good morning. Thank you for this opportunity. My name is Marianne Rothman. I'm the Executive Director of the Council of New York Cooperatives and Condominiums, which is a membership organization of more than 2,300 housing cooperatives and condominiums located throughout the 5 boroughs of New York City and beyond. And it's our members are the homes of over 175,000 New York families. My organization provides information, education, and advocacy to our members. Many of the co-ops and condos that form our membership were converted from rental properties. Since 1982, rent-regulated tenants who opt not to purchase their units have generally had the right to remain in their apartments. And even prior to that, seniors and individuals with disabilities could exempt themselves from the conversion process and remain in their homes. As a result, there are rent-regulated units in many of our member co-ops and condos. And in some cases, those rent-regulated apartments are now owned by the co-op or condo, generally because a sponsor has defaulted. Rents for these units can be considerably less than the cost of operating the units. So the cooperative or condominium owning the units must budget to cover the shortfall through carrying charges paid by the other shareholders or unit owners. And if it's the former sponsor or an investor who owns rent-regulated units with shortfalls, that owner is still responsible for paying the maintenance, the carrying charges on the unit. So there's a constant risk that that owner may default and walk away from the rent-regulated apartment. Co-ops and condos are self-contained communities governed by volunteer boards whom the shareholders and unit owners elect from among their neighbors to set policy and to oversee the operation of the building. The board tries to do this in a way that provides quality housing at reasonable cost. Prudent co-ops and condos will also try to set a budget that funds reserves to cover the constant need to repair and replace building systems. But beyond that, co-ops and condos operate pretty much at break-even, which is why the operating costs of cooperatives and condominiums in New York City give good insight into the actual cost of operating similar rental properties. And that's why you have my green book in front of you. It's the most current of our comparative studies of operating costs. We've been compiling this comparative study annually since 1980. We collect from as many co-ops and condos as we can, their financial data, and organize it. We abstract the operating costs. We try to not include capital improvements when they can clearly be discerned. So this is straight operating costs in 8 categories based on location, size of building, et cetera. Everything is dollars per room per year, which seemed to us from the beginning to be the easiest common denominator that we could have. If we went by units, you have a studio compared to a six-room apartment, and it wasn't effective. But it takes a little minute to adjust to the dollars per room per year. You have, in each of the categories, first you have the chart of the dollars per room per year in the various categories. Then you have the grid with a 10-year recap of the range, the median, and the average for the various components. There's no question, and I've been sitting here for a while, everyone has said it, operating costs increase year over year. If fuel prices drop, then government mandates eat up the budget. Labor costs increase annually. Property taxes continue to grow at a very fast pace. And I point out that the law requires that co-ops and condos be assessed as if we were comparable rentals. This was a law put in place in 1981 when there was probably a rental building across the street, and it was relatively easy to do comparable taxation. Now it has become a very interesting art rather than a science, but the fact that the Department of Finance is constrained to develop some sort of rental pattern for co-ops and condos should pretty much mirror the kind of property tax pain that owners of rental property are also going through. Our property taxes have increased tremendously year after year. For owners to be able to continue to operate rental properties, they must be able to collect rents that cover the ever-growing costs of operating their buildings, plus a reasonable margin for profit. When co-ops and condos own rent-regulated units, growing shortfalls between rent collected and actual costs impose a hardship on the other owners. So my organization urges the Rent Guideline Board to allow rent increases attuned to the cost of operating property in New York City today. Thank you.
Thank you. Who's going to go next?
Mike, would you?
I am Mike Slattery with the Real Estate Board of New York, and we're a trade association with 17,000 owners, developers, managers, brokers, and other real estate professionals active in New York. We'd like to provide some perspective regarding this year's rent adjustments. New York City's rental apartments are vital assets for the city. These vital assets require regular and reliable capital investment, which is expensive and necessary. From experience, we know what can happen to apartment buildings that lack the revenue needed to finance essential and costly capital repairs. Also, New York places a high burden on owners to maintain their buildings with requirements such as local law 11, local 87, as you just heard. These expenses are unavoidable. In addition, we have regularly objected to the Department of Finance's unilateral and arbitrary reduction in expenses submitted on RPIEs. This action artificially increases the building's net operating income as well as its market value for tax purposes, placing an inequitable tax burden on rental apartment buildings. The focus of our concern today in this regard is the emerging pattern of nominal rent increases. The establishment of such a pattern will make it more difficult to finance ongoing capital improvements and will eventually influence lending for rental apartment buildings and new affordable housing development. For example, until about 10 years ago, lenders were underwriting loans for new housing development, assuming real estate taxes at 20% of rental income. As taxes on apartment rentals increased, due in part to a systematic pattern of shifting taxes away from single-family homeowners and onto income-producing properties, the level of taxation increased. As a result, some properties are paying in excess of 30% of their gross income in taxes. Lenders then began to adjust their underwriting analysis to assume these higher taxes. The result of this change is that the amount of capital the builder can borrow declines, and the amount of equity needed increases, which is significantly more costly than debt. This increases the cost of capital for an entire project, and for some market rate projects, this change meant the project would not go forward. Based on the nominal rent increase over the last 2 years and the anxiety that a third year of nominal rent increases, we are concerned that lenders who typically project on average a 3% revenue increase in income will stress the income profile and underwriting standards, assuming that these nominal rent increases are the new norm. This would impact financing for capital improvements as well as capital for new affordable housing projects subject to RGB oversight. The RGB research shows that property taxes are the single largest expense for most residential buildings. Over the last 15 years, the tax burden for these Class 2 properties has averaged double-digit increases. This level of taxation is unfair, unsustainable, some would say confiscatory, and a stop sign to building and maintaining affordable rent-stabilized housing. First, the Class pays it. The Class 2 property with the rent, which are rental buildings, pays a disproportionate share of the tax levy. Class 2 accounts for 23% of the market value and 36% of the tax levy. This disparity is done to lower the tax burden on single-family homeowners in Class 1, which accounts for 45% of the market value and 15% of the tax levy. Second, apartment buildings also are unfairly taxed even within its class. The New York City's Independent Budget Office in 2006 report concluded that residential rental properties are paying a significantly higher effective tax rate than co-ops and condos. The dramatic shortcoming of this method of co-op buildings was made clear in a 2012 report by the Furman Center. The report identified 50 individual co-op apartments in 46 multi-unit buildings whose sale price was greater than the city's market value for the entire co-op building. These undervalued properties were concentrated in Manhattan and Brooklyn, but one striking example was a Manhattan co-op in a 13-unit building sold for $50 million, and the entire building was valued at $15 million. In recent years, many of the new rent-stabilized buildings are 80/20s. As a result of the high tax burden, we are seeing a number of these buildings being sold by traditional long-term rental building owners. Often these buildings are sold to converters who are less concerned with the high taxes, since the conversion will lower the tax bill because of the inequities in the law and make them eligible for the co-op condo abatement. A pattern of nominal rent increases while these units are regulated will give these owners just another reason to sell or convert these rental apartments. In conclusion, New York City's tax policy of imposing unsustainably high property taxes on rental apartments and RGB's guidance of actively suppressing rental income growth is a recipe for placing our inventory of rent-stabilized apartment buildings in jeopardy. Thank you.
Thank you. Mr. Freund.
And Mike's testimony is not to say that real estate taxes in co-ops and condos haven't increased also over the period of time, but
Give me your own panel next.
So thank you. I appreciate the points. My name is Jack Freund. I'm Executive Vice President of the Rent Stabilization Association. I'm here on behalf of our 25,000 members who own or manage the majority of the nearly 1 million rent-regulated units in New York City. I've distributed testimony. I'm not going to read it. Hopefully you will. And we will, after you do a preliminary guideline, as is our past practice, we will give you a submission to comment on those guidelines, which will touch on quite a number of factors that we won't have time to deal with here. So at this point, I think what I'd really like to do is focus on, to summarize a little and add to some points. We've covered a lot of ground here. As various speakers have said, we are looking at another 0% increase based on the prime considerations that you are looking at, the price index, the income and expense study. Prior speakers have pointed out the deficiencies of those measures if you just look at the numbers alone without additional consideration. I've been doing this long enough now to recall when it was the practice of the Rent Guidelines Board in its explanatory statement to look to analyze both qualitative and quantitative factors. The distinction there being is, some things you can measure and some things you can't. And even for those things that you measure, you sometimes have to look at those with a slightly jaundiced eye to understand what those numbers are really telling you. So, for instance, the price index, which is negative this year, leads to the conclusion that costs have gone down for property owners. We've just heard from Mary Ann, costs never go down for property owners because there is always something else to do with our aging housing stock. But I'll just add one element to that is if you look at the staff's income and expense report for this year, and you look at for the last year for which we have income and expense data, which is 2014, and I want to remind you that the data we are looking at here is 2 years old, predates the 1% increase of 2 years ago, predates the 0% increase last year. So it's very important to realize that this is dated, but even so, if you look at 2014, you compare the costs as reported in the RPIE statements, which was 5.6%, and you compare that to the adjusted PIOC presented by the staff, which was 1.7%, you can see that there is not a necessary relationship between the PIOC and costs that owners actually incur. And by the way, in years when the price index is high, it is the role of the tenant advocates to cast doubt on the price index, and their line is, well, it's not costs, it's just prices, and owners really didn't spend that much. Well, the shoe's on the other foot now, and I get to say that the price index is low, but it's just prices, it's not costs, and owners did spend more than is indicated in the price index. With regard briefly to the income and expense report, where we have NOI increasing, we've had a bit of discussion on that. Again, the income and expense report needs to be taken with a grain of salt. And I'll mention, we've heard about the way in which the income and expense data takes into account income but not costs. Let me just mention briefly that the sample is also not representative. This sample, which is a large sample at some 16,000 buildings, but there are 45,000 rent-stabilized buildings in New York City. So this report leaves out 2/3 of the stabilized buildings in the city, and these are the buildings that don't have to file income and expense reports. They are the smaller buildings, 10 units and less, and we know that those buildings have higher expenses and lower incomes. So we would have an entirely different picture if these buildings were factored into the income and expense report. We've said this repeatedly, but it doesn't happen, but I'll say it again. This is a non-representative and incomplete picture of owners' income and expenses. The other notion that comes out of the income and expense report, and this was mentioned, is that somehow this board is tasked with regulating profitability. Nothing could be further from the truth. There is nothing in this board's mandate that tells you or indicates that you even can regulate profit, and you can't. And if you could, let me just mention, if you could, then you would end up with a much different result. For example, the maximum base rent system, the rent-controlled system for the few units that remain, does take profit into account in its calculations. It uses all the data that the RGB provides, it uses price index data, and it adds a component for a return on equity, in other words, for profit. And when that formula, and this is a formulaic approach, there's no discretion in this process for rent-controlled units, the HCR released an MBR adjustment this year, covers a 2-year period, 9.6%. Over 4.5% a year of rent increase is what the formula which factors in profit boils down to. If you want to go that way, that's okay. We'll take that. So we have not talked a lot about affordability, but this is a topic that obviously you'll spend the afternoon here hearing about affordability. I'm not going to talk a lot about it now, but we will address those issues in our submission. There's a lot to be said there. We've said a little about what's wrong, had addressed a little about problems with affordability numbers. I'm not going to get into it except to say that It's clear that it is a major concern, it's a legitimate concern, and it is probably the keynote concern of this administration. The mayor has staked his administration on affordability. What is odd about this is that the mayor seems to recognize in all other respects other than the rent-stabilized universe that to create affordability costs money, okay? The mayor is spending billions of dollars to create new affordable housing. Mayor has committed over $200 million to pay back rent for tenants to avoid evictions. We don't disagree with that approach. We think that's the right approach. The mayor has also, when it comes to the water board, managed to keep the rate increase lowest it's been for quite a number of years. Plus, he is proposing at the water board to provide a further credit against water and sewer rates for a certain segment of the affordable housing universe, and that is as it should be. If you want affordability, you have to buy affordability. Only when it comes to the rent-stabilized stock, the largest existing source of affordable housing in New York City, does this mayor not somehow seem to understand that you can't get something for nothing. He believes, he campaigned on it, he thinks it's legitimate to get a zero increase in order to preserve affordability and place that burden squarely on the backs of this city's property owners. If that pattern and that belief keeps up, and we ask you not to be complicit with this politically motivated, politically driven scheme for keeping rents at zero when real estate taxes go up. If the mayor wants to truly provide affordability in the rent-stabilized sector, all he has to do is freeze property taxes. And then we would have a great degree of affordability introduced. But that's not the course that this mayor is asking you to do. He wants to keep raising real estate taxes and water and sewer charges. You've heard about all the other costs that keep going up, but he wants you to do a zero rent increase. We urge you not to be complicit in that politically motivated ideology. Thank you very much.
Thank you. Okay, we have some time for questions. Any questions for this panel? No
Saved you
questions.
some time.
All right.
Thank you very much.
Actually, sorry, we do have a question.
So a little bit of this is for Andrew. So, Mary, thank you for your testimony again this year. In my career, I have managed sponsor-held units. I'm very familiar with them and the annual disclosure to the Attorney General. Has that ever been a document set this board could get? So for board members who haven't managed unsold sponsor units or that situation, every year the person who holds an unsold sponsor share in a co-op or condo has to attest to the Attorney General that they have funds available to pay the annual common charges on that apartment, because in many cases, as Mary pointed out, these common charges are well below what the rent actually being paid on the apartment is. So there's obviously a deficit. You're running a deficit business. Has that ever been a data set that this group could get, that just, this is the cost? The Attorney General knows it, but you think that's fair way to put it? Okay.
So it's something that the data is filed with the Attorney General's office, is that?
Right, there's an annual filing.
Annual filing? I mean, we could ask for the data, sure.
Okay.
But as far as I know, we haven't considered it in the past.
Okay.
How many rent-stabilized units do you track or have in co-ops, in condos?
We're not, as an organization, we're not in a position to do that level of tracking, but probably the co-ops and condos throughout the city are, on average, about 60 to 75% owner occupied. There's still a very significant rental component throughout the city.
Do we know how many of those rentals are stabilized?
Well, they're likely to be very close to all stabilized rents.
Because of the conversion process.
Because of the conversion
All right.
process. Once you, the existing tenant can stay on, but it doesn't perpetuate.
Yeah, I mean, I think there's two components to that. Obviously, it's very rare in New York State to have an eviction plan that's, I can't even think of one in the past 20 years that's been improved. So all eviction plans are non-eviction conversion plans. And part of the non-eviction conversion plan is it does go to a consumer protection of rent stabilization, even if the unit was not prior in rent stabilization.
Could I just ask along those lines, you're not sure how many units are rent stabilized in the portfolio of condos and co-ops, but can I ask you, most of this information is really Manhattan-centric, and I'm wondering where, the volume in the Bronx and Queens of co-ops and condos, it's hard to sense from outer Manhattan where these are located.
Brooklyn is just very, very heavily co-ops and condos all over the place. A lot of the condos are new construction. They tend to be small buildings. Frankly, it's much harder to get a hold of their financial statements. But a lot of those would be in the category of, small buildings in Brooklyn with under 100 rooms. In the Bronx, very heavily Riverdale, then there is Co-op City, which isn't in these statistics. I wish I could get their financial statement. The big condos in the Bronx are Park, Chester, North, and South, which are which are between them about 16,000 units.
So of the buildings that are co-op and condos outside of Manhattan and the small buildings,
Queens.
Brooklyn, do you have a lot of rent-stabilized buildings that were converted to co-ops
Oh,
in the Bronx and in Queens?
To my surprise, the Riverdale buildings, which tend to be high-rises, averaging probably 100 to 130 units, their conversion process has been very, very slow. So, they're still probably below 70% owner, sold away from the sponsor in the vast majority of those buildings, and this is probably, 25 to 35 years after conversion. An awful lot of people stayed on in their apartments.
And I agree with you, it is a Manhattan-centric thing, but even on Fifth Avenue, Lower Fifth, around NYU, all of those buildings have substantial rent-stabilized tenants still in them, even though they're co-ops from the late 70s, early 80s. A lot of those buildings, when you go to look at units in them, they're still, I agree with you, they're still not even 65% sold, which gets to be a problem when a purchaser wants to get a mortgage, because a lot of banks won't lend when there's a high rental concentration.
Or the rates are higher.
This is just not my experience, Scott, and like in my co-op, we have very few rent-stabilized apartments left in our building and in buildings throughout the neighborhood where I live.
When did you convert?
In the 80s.
In the early 80s or?
86.
Okay, so there already was non-eviction conversions, but yeah.
But in buildings throughout my community, there are, in the co-ops and condos, there are very few rent-stabilized tenants left in most of these buildings, but there are some, but you see a lot more
Yeah,
in
but
the Bronx, like if you look in a building, Lafayette Estates, which is a co-op, it's half rent-stabilized, but they're not selling units because the owner who purchased is maintaining all those units, and doesn't want to sell those units to anyone who lives there. So there are neighborhood-by-neighborhood issues, but I do think there might be borough distinctions on co-ops and condos.
If you're saying that more of Manhattan is more fully converted to owner occupancy, I tend to agree. An awful lot of the other borough conversions, the existing tenants just said, we want no part of this, and have stayed on.
I just want to emphasize, to comment on Mary Ann's testimony, I don't think the critical issue here is how many rent-stabilized units there are in condos. Certainly, it's a minority of the total universe of rent-stabilized apartments. I think what is important about her testimony is on the cost side, that it is clear in co-ops, which, as Mary Ann said, are not profit-motivated, costs have gone up every year, and that is an indication, I believe, of the larger universe of stabilized apartments where similarly, costs go up every year, year after year after year, regardless of the peculiar and particular and aberrational circumstances that you're looking at this year as a result of the drop in fuel. We believe that costs to operate rental buildings in general, co-ops as well, continue to go up, and that this board needs to recognize that reality, look beyond the numbers, and realize that after increases of 1% and 0%, it's time for a reasonable rent increase.